Hi, welcome everybody. We are here today to talk about GDPR and how it affects our work. It's my pleasure to introduce Helen Harvey from H3 Solicitors, who's going to hopefully demystify the process for us a bit. Hi Helen, welcome.
Thank you very much, Maya. Good morning, or sorry, I shouldn't say that.
Whatever time you're watching it, yeah.
Yes, I've been asked to talk to you about GDPR, which I'm sure you've heard a lot about in the news, and I know that some of the members are quite concerned about how this will apply to them. So this training course is to cover some of the key points and issues, and then at the end I think we're going to discuss some of the questions that have already been raised by the members themselves. Yeah. So first of all, just to cover the legislative background, GDPR actually stands for General Data Protection Regulations, and it derives from an EU directive in 2016, but it will come into force in the UK on the 25th of May 2018. So obviously this is now less than a month away, and hence why people are somewhat concerned. It deals with data protection, and when we're talking about data, it's how we collect data on individuals, how we store it, and how we use it. That's the purpose of this legislation, is to provide a framework for that.
What do you define as data?
Okay, for these purposes we're talking about personal data only, and it is information, mostly written, but it can be in other forms as well. But it's data that identifies an individual, okay, even if that involves pulling together more than one set of information. This does not cover information about organisations. So in the context of the therapists, whilst they may well be working from home, they are essentially running a business. Yeah. So business to business is not covered by this. It is data on individuals. Yeah. Okay. So here really we're talking about client data.
Yeah, and supervisory, yeah.
Yeah.
And supervisory data, yeah.
Okay, and you may well see reference to sensitive personal data, and I've got a summary of that on a slide. So
okay,
if we can call that up.
Yeah.
This just summarises what sensitive personal data refers to. So again, it is information relating to an individual, but it's where it might contain reference to racial or ethnic origins, political opinions, religious beliefs, membership of a trade union, physical or mental health, sexual life, criminal offences and convictions.
Yeah.
So obviously in the context of the activities that you're involved in, quite a lot of the information that you are collecting and the data you hold may well be classed as sensitive personal data. Yeah. Because of this list. So when it comes to sensitive personal data, it simply means that there is an enhanced requirement for additional security, and also much more of a focus on consent, but we'll talk about that in a moment.
Okay.
Okay, so okay. So in terms of why this relates to you as practitioners, it's because of the records that you will be holding on your clients and the fact that there's so much personal data, and particularly sensitive personal data, you will be classified as data controllers for the purposes of this legislation.
And do we still have to register with the ICO?
Yes, unfortunately you do. Originally when this was discussed, there was a claim that there would no longer be registration with the ICO.
That's
but
what I had heard.
That is not the case.
Okay, so we still have to register, still have to pay.
Correct. I think the ICO have realised that they still need to collect the registration fees. So then, there is no way you can do that without holding a register.
Yeah.
They do say that there is a change in that they won't be holding a lot of information about your activities, but effectively they will still have all of the information about the organisation and contact details, etc., which will still be a public register.
Yeah, which is one of the concerns that our members have raised, having
Yes.
our home address on the ICO register. And
yes, and we have actually spoken to the ICO about that,
yeah,
and they don't have a solution in the sense of agreeing to take you off the register, but what they do say is that you don't have to use your home address. You can use a registered office type address. So one of the issues we've been discussing with the trustees of COSRT is whether a service can be offered whereby you can use a registered office address rather than a home address. I haven't got a final decision on that yet, but that is being discussed.
Yeah, because I think that would be quite useful, because at the moment it feels like we're protecting everybody else, but our private details are out there.
Yes, it's quite ironic in the context of what we're discussing here, but unfortunately that seems to be the case, and the ICO have not got any provision to deal with that.
Yeah.
So hopefully we'll be able to come up with a sensible solution relating to this registration only, obviously not any other function.
No, we will keep the membership posted on whatever we come up with.
Absolutely. Okay, so that's going back to the idea that all of the members are data controllers in their own right, quite separately from COSRT, who will be data controller for the membership and for their own administration purposes, but each member will be a data controller for their client information.
Yeah.
Okay. In terms of managing and monitoring data protection, the basic principles, and that's on the next slide, Maria, if you could move on to that. These are the key principles of data protection, and they were introduced under the Data Protection Act of 1998, so they have been here quite a long time, 20 years.
So
and none of those...
Changed.
Sorry?
They haven't changed.
The actual principles have not changed at all. They still apply. What will happen under GDPR, and I'll just summarise what's going to change under GDPR, is that there are going to be some changes in focus and some enhanced rights, for example, for the data subjects themselves to access data. So I'll come on and talk about that in a little bit more detail.
Yeah.
But as you'll see, these are the key principles: that you should only process the data fairly and lawfully. It should only be obtained for lawful purposes. It should be adequate and not excessive. You should keep it up to date and ensure it's always accurate, and then dispose of it when it's no longer required. There is much more of a focus on that aspect.
Yeah.
It should be processed in accordance with rights, and we'll come on to talk about that. Security is a big issue, and it should not be transferred outside the jurisdiction, which for these purposes is outside Europe.
Okay.
So the biggest implication there is just reviewing your computer servers and see where information is held, and see whether it's held in the EU. Most of the big providers now will provide you with their data protection policy and will assure you that it's held in Europe rather than in the United States, for example.
Okay.
Okay. So in terms of looking at other issues that are changing under GDPR, there is very much a focus on privacy by design and by default. This is one of the big strap lines. And the idea is that you're supposed to have systems in place to the extent possible to ensure that there are no breaches of data. And a breach means that data is destroyed, altered, lost, or accidentally disclosed to someone.
Okay. So leaving your laptop on the train, sort of.
Absolutely. This has always been a big issue, but increasingly so, and particularly with all the advances in technology, which fundamentally involve sharing devices and iClouds, etc.
Yeah. So
it's just focusing on that aspect, because there is a requirement under this legislation to notify any breaches to the Information Commissioner's Office, the ICO, which is the regulator for these purposes, within 72 hours of the breach occurring. So that's not very long, actually.
Yeah. And do you know what happens if you do notify them? Do they do something about it? Or?
I think depending upon the scale, I imagine it will be like the notification to the Charity Commission of serious incidents that as long as you have appeared to have dealt with it and you are notifying them,
Yeah.
probably they won't take any action, but of course they could always investigate. And I think where they will focus is if they hear about a breach of data from another source, so via social media, for example, and it hasn't been notified. I think that is the case where they will investigate and could potentially impose fines.
Okay.
And to come on to that topic, that is one of the reasons why there has been so much fear about GDPR, and that is because the ICO in the future will have the ability to raise much higher fines.
Okay.
At the moment, the fines are limited to £500,000, but under GDPR, that will be raised to €10,000 or 4% of annual turnover, whichever is the greater.
Okay.
So the scale of those fines is enormous.
I think yeah, for most therapists, that's not going to be so much of an issue, but big companies, yes, I can see.
Well, I think for any big charity, that would be very significant. So obviously for a therapist, it would be ridiculous if they got a huge fine. But to put it into context, the current limit is £500,000. The most any charity has had raised against it is £25,000.
Okay.
So clearly the ICO is proportionate in the sense of smaller practitioners, smaller organisations, charities.
Yeah.
So I don't think people should be terrified of these fines, but just it's worth bearing in mind that the ICO will have this ability to raise big fines if they consider it appropriate.
Yeah.
Okay, so that's one of the more significant changes.
Yeah.
Some of the other changes, there are a couple of changes that probably won't apply to your members. So appointing data protection officers, that's only for large organisations processing large amounts of data.
If you're self-employed, working for yourself,
yes,
using the data processing. Yeah.
No, you won't need to appoint an officer. I mean, you probably won't have employees. There are also things called privacy impact assessments, which if you become involved in a new project, theoretically you should carry out an assessment of how that will impact on your data protection matters. So that's worth remembering in case you change your practices or get involved in something new. But again, it's relatively not particularly applicable to the membership here. Yeah. What's more applicable probably is the access, data subject access rights, and this right to be forgotten. Yeah. So just briefly to touch on those, there is already a right for data subjects to be able to contact you and ask you what you're holding. Yeah. You currently have 40 days in which to reply, and you can charge for providing that information anywhere between £10 and £50. Under GDPR, that same right will apply, but you will only have a month in which to respond, and you can't charge for providing that information. Okay. I think a little bit later on we'll touch on some questions from the membership, and I'll go into that in a little more detail.
Yeah, thank you.
There is also this right to be forgotten, and again we'll talk about that in more detail, but where people whose information you're holding can contact you and say, I wish to be removed from your database. And again, we'll come on and talk about that in a little bit more detail because it's not that straightforward or simple. Okay, I think the only other significant new area under GDPR is consent. And when we're talking about consent here, it's nothing to do with clinical consent for that your clients might sign in relation to the services you provide. It's not that, it's consent for dealing with the information itself. So we're talking about the data itself. So when you are processing people's data, there are various justifications, if you like. They're described as conditions, but justifications for processing that data. And you'll see a list of 6 on the screen now. And you'll see that consent is only one of them. So there are other ways in which you can process data where you don't have to get consent. So if it's performing a contract, you can use that as the justification. or it may be that you can say it's necessary for the purposes of legitimate interest. So, for example, contacting a membership about their membership rights or their annual payment to the organisation would often fall under contacting them for the purposes of legitimate interest. So you don't need explicit consent for that.
I think things like we send membership updates, and I think they communicate about things that are necessary for the members to know.
Yeah, that would probably fall within legitimate interest.
Yeah.
If, however, you were to be contacting your clients or the membership and carrying out a form of marketing, so trying to generate more business, trying to generate more income, that's where it becomes difficult to say that that's a legitimate interest. And it's in those situations that you usually have to get explicit consent. So the next slide just summarises what consent means for these purposes. So if you're seeking consent, and again, I stress this is only for managing data, so it's not to do with clinical services. You do have to have explicit consent. So it's got to be freely given, specific, unambiguous, and you've got to have evidence. So it's got to be a conscious tick yes, rather than an assumption that if they haven't said no, that they want to be contacted. So if you've heard a lot about consent, usually it's to do with direct marketing. So organisations that are contacting the database that they have, many of whom are donors, and asking them for funds. In those circumstances, you have to get explicit consent. Yeah. I think in relation to the membership here, what I think you may wish to do with your clients is have some form of explicit consent in your agreement with the clients that you are able to contact them by email, for example, and you will also include in there details of what you do with the data that you are holding, and we'll come on to a privacy notice later, which will list what that should contain. Yeah,
but everything should be in writing.
I think so. I think under GDPR, an awful lot of the basis of GDPR is having evidence that you've done certain things, and it's quite difficult to evidence things if they're not in writing. Theoretically, many things can be verbal, but then you've got no evidence. So I would suggest that if any members have agreements with their clients that aren't in writing, that they should perhaps review that practice now.
Yeah.
Yeah.
Okay.
The only final thing to touch on to do with consent is children. I don't know if any of the membership are dealing with children, but again, for the purposes of data protection only, the age of consent for children now is going to be 13. For the rest of Europe, it will be 16, but the UK has taken the decision it will be 13. So for the purposes of contacting them and managing their data, if they are 13 and over, they are able to give consent to that themselves, rather than requiring the consent of their parents. Okay. Right, so just thinking about actions that the membership might need to take to bring themselves in line for the requirements under GDPR. We've talked about registration with the ICO, and there is a fee for that. Usually for smaller organisations and individual practices, it's £40 under the new regulations,
as well.
35.
Yeah.
That's gone up, yes, of course.
Of course.
That will continue. There will still be an annual fee which will be collected. Okay. So if you're already paying, that will just continue. If not, you'll have to register.
Yeah.
Other points to note, security we've mentioned. It is very important to look again at the security of your filing systems, your devices, so your computers, but also things like handheld devices, phones, tablets, all of that, and make sure that they are secure as far as possible. The National Cyber Security Centre, which is part of GCHQ, has just issued a small charities guide. Okay. So whilst your members aren't charities, the same principles will apply, and it's worth looking at that, because it does go through
You can find that online.
That can be found online, yes. If there's any difficulties, we can provide a link. But
yeah, National Cybersecurity Centre. Okay.
That's right. And they've produced this small pamphlet just looking at security for small organisations. So
quite difficult to know.
Yes, that's well worth reading through. Otherwise, I mean, obviously you can take advice from individual IT consultants, although that can end up being expensive, but it may well be worth it in this context just to be completely sure that you are compliant as far as possible. So you've got as much password protection and encryption as possible within your practices.
Yeah, if you use them for any kind of client purposes.
Absolutely, yeah. And it's storing data, and the problem with computerized data, and when we're talking about data here, it can be computerized, but it can also be paper, and it can be a mixture of the two.
Yeah, so it doesn't matter what it is the content rather than how it's stored.
Absolutely right. And of course, so when you're looking at security, it's the security of how it's held, and then also looking at how if you are deleting any information, which we'll come on to, making sure that that's done securely. So, knowing that hard drives, you have to have them professionally cleaned in order to ensure that things really have been deleted.
Yeah.
And many computers, when it says you've deleted information, it's not strictly correct because it's still there on the hard drive somewhere and can be recovered.
Yeah, so if you're disposing of old computers, you'd need to take care.
Absolutely. And if you've got a backup system, I mean, this is something I've discovered, that if you delete information and then you have a need to call up your backup because of a power failure or something like that, then you quite often find that the backup systems reinstall everything. So information you thought was deleted actually is no longer deleted.
Yeah.
So it's just reviewing all of those things and making sure you understand the nature of deletion. In some ways, it's easier with paper files. When you shredded them.
Yeah, exactly. They're gone.
But with computer files, not so straightforward.
Yeah, sounds a bit daunting, but yeah.
Yes. So other issues to check: review and update your paperwork to make sure that you've got in most of your paperwork probably some statement about data protection. And we'll come on to privacy notices.
Yeah.
Have a look at updating your policies if you're holding policies. That will certainly be more the case for COSRT. There will be revised practice guidelines and policies being produced over the course of the next few months, probably.
Yeah.
Make sure you've got good record keeping and an evidence base, as we've said. Make sure you've got a good system for dealing with complaints. Privacy notices, perhaps we could move on to the next slide, which should summarise what you need to include in a privacy notice. Now, when we're talking about this, it could be something that you put on your website if you advertise on the web. If not, it's probably something you will put in your paperwork that you agree with your clients. There would be a little section in the same way that you have a section now on confidentiality. Yeah. Be a section on how you handle data. So it's saying why you're collecting that data, what's the purpose, who else might have access to it, so third parties. Yeah. And that's worth thinking about, because sometimes it's quite surprising when you think about who might be able to access it. So anything from accountants to people who are handling your IT systems, for example.
If you have sort of full details and things, and if you hold everything on the computer.
Yes, absolutely. So it might be people who have access to that information that you might not necessarily wish them to, but it might also be third parties that you're explicitly passing information to. So local authorities, social workers, I don't know, but there might be third parties involved in this.
Yeah.
And to that extent, you should certainly be transparent about that. So in your privacy notice, you might say, we may have need to pass this to X, Y, Z. Yeah. Be as transparent as possible. But also, if there are certain things you're not doing with that data and you can explicitly say so, then it can be quite a comfort to the persons that are signing the paperwork. So you might say, we don't sell data. You might be able to say, we don't pass it to third parties.
Yeah.
So just use this as an opportunity.
I think most clients come into counseling sort of expect it to be confidential and private. But
yes.
I think in all our contracts we have the clause saying, well, there are these cases, but there's also a clause kind of, I keep data for so long.
Yeah.
It's stored in a locked, secure cabinets, whatever it is.
Yes, absolutely. And if there is going to be any referral of information in certain circumstances, it's worth flagging it up here. So as you say, as much as anything, the privacy notice is managing the expectation of the client.
Yeah.
So if there's anything they need to know in relation to their data, put it in here, because then you've got less likelihood of a complaint.
Yeah.
If they know about it up front and you get them to sign the agreement, then they can't then come back and say, well, we didn't know this was what you're going to do with our personal data.
Yeah.
Okay. Oh.
Yeah.
Yeah. How long information is going to be held, retention period. I mean, that's an important point. At the moment, under the practice guideline that COSRT issue, it says to hold information, I believe, for 7 years from conclusion of the work that you're doing with them, so the conclusion of the relationship. In principle, that won't change. There may be certain circumstances where indeed you might extend that. So, you know, in situations to do with children or anything to do with child protection or protection of vulnerable adults, there might be circumstances where that period of time might be longer. Again, I think COSRT will be issuing revised guidance on this.
Yeah.
Obviously, you mustn't hold information for longer than is necessary, but equally, you don't want to be driven by GDPR to dispose of information that you really need in the future as evidence, and in particular, if there is a complaint.
Yeah, it's quite a hard call to sort of, when is it suitable?
Yes, very much a hard call, which is why I think there will be some further guidance issued on this. But as long as you justify holding something for a longer period, then you won't be criticised for that. The whole point behind retention is to do away with this idea that you hold documents indefinitely, simply because that's easier than dealing with them properly and appropriately.
Yeah.
And it's also the data subjects wish to feel that you're not holding information about them indefinitely, that there is a limit to that. So that's the whole point of this. But I think lots of people are becoming so panic-stricken that they're disposing of information that actually they should be holding and keeping. Yeah. So just bear that in mind.
At the moment it's still 7 years, but
yes,
the COSRT is reviewing it.
Yes, exactly. And it's 7 years from the end of the piece of work or advice, but it's also 7 years from the end of the resolution of a complaint. So let's say that your relationship with a client terminates now. In a couple of months' time, they make a complaint and you deal with that and everyone's satisfied. The 7 years runs from the resolution of the complaint. So that would then give you a little bit longer, but it's just to ensure that in the future you weren't subject to some litigation which has a 6-year time limit to find that you've disposed of all of the information that would provide you with a defence.
Yeah.
Okay. Okay. So that was what I wanted to say on privacy notices, and as I say, you probably include these in your paperwork and potentially on your websites.
Yeah.
But so that sort of summarises a lot of the things that are changing under GDPR. A lot of it is about ensuring the systems you've got in place are adequate, A, to protect the data, and then to deal with things like subject access requests.
Yeah.
And the need to delete data upon request. So perhaps it might be worth moving on, Maria, to deal with the questions that have come in from the membership.
Yeah. We have covered some of them with the registration with the ICO, yes, we still will
Yes.
have to do that.
Yeah.
And we talked about the home address
Yes.
being on the register, which we are seeing if we COSRT can provide an address that could be used by members for that purpose.
Yeah.
So how we have touched on sort of how to ensure that devices and systems are secure.
Yes, I mean, I've mentioned the guidance from the National Cyber Security Centre, which is worth looking at, and also any advice you might get from your regular IT consultant, who presumably you will have someone who will come in and assist you with your systems or problems.
Yeah.
A lot of it is just addressing, as much as anything, the sort of use of your devices, the personal security you might have at home.
Yeah, making sure everything is password protected and only accessed by you and not the whole
family. Absolutely. And maybe I think there's been some suggestion that it may be that telephones, you might have a separate telephone for work from private calls, and it's that sort of thing. I mean, without making it too onerous and expensive, it's just considering how you can really separate out and protect that data.
And even on the telephone, not having kind of the client's full first name, surname, all the details sort of.
Absolutely, and thinking about emails and how secure they are, because in effect emails are not secure, full stop. So you've got to assume that anybody could read your emails if they're going to contain.
At the moment, I have it in my contract that emails and texts are not encrypted.
Right.
Do you think it's enough to state that so the clients know that that's the case?
That certainly helps. It may be that if you were to send a sensitive piece of information by email, that maybe you'd attach it as a separate document, and now you can get these passwords where you can only open the document with passwords. So it may be worth thinking about that sort of additional security measure. But just bear in mind that emails really aren't very secure.
Yeah, I know. Do I need to contact my database about GDPR?
Well, I think a lot of the scaremongering that's been in the news has been about contacting databases about direct marketing. So if you're not doing any marketing to your client database, then probably there's not an absolute need for you to contact them now. As I said, I think it's probably sensible to update your agreements with them. And for example, contacting people by email, you need their explicit consent for that. So that should just form part of the contract you have with the client. Rather than having to go now and contact them all in one go, you might if they're regular and ongoing clients, you might want to update your agreements with them and then put in place new paperwork for new clients.
Okay. What happens if the client asks for the information to be deleted and then a complaint arises? I think that is something that a lot of members have asked.
Well, this right to be forgotten is a bit of a misnomer, really, because if you have a client contacts you and says, please remove all of my information from your database, under the legislation, you can't actually remove everything, because you've got to keep what's described as a suppression list. And that is a list of people who've contacted you and asked to be deleted. And you need that as evidence to show that you've done it. So this is a little bit surreal, but you have to have enough information about them to be able to identify them, to evidence that you've taken them off your database. Now, you might also have a need to retain some information about that client for defensive purposes, as we've just said, that to contend against a complaint or litigation in the future, you might need to retain that information. So I think what clients need to be told when they ask to be deleted is to say that we will remove your details from our database for the purposes of processing. So we will not contact you, your data will not be used, but we are required to hold some records in the event of future complaints, etc. But we will only hold them for, then you say, your 7 years or whatever it is, and after that time all of that information will be destroyed.
Okay, so it's kind of a legitimate to say, well, I can't remove everything.
Yes, exactly. And it's a right to be deleted from the point of view of being contacted in the future,
Okay.
really. But it's not a right to delete absolutely every record you hold about them.
Okay, yeah, because I think that's really not clear when reading the documents. I think it's quite good to have that clarification.
Yes, and I think the problem with GDPR is that other things do override GDPR, and so it is a case of weighing up the situation and saying, okay, well, obviously we've got to comply with this statutory right for your information to be deleted, but equally there is a sort of business imperative that says we have to be able to defend ourselves in the event of a complaint.
Yeah.
So it is just clarifying to the client that yes, we will take you off your database, but no, we're not going to destroy all records until that 6 years is up.
Yeah. Okay. And what about if you're sending information about the client to another agency? Is it okay to copy them in and agree, or kind of how would you deal with that?
I do think if information is going to be passed to a third party, that is a situation where explicit consent is needed.
Yeah.
So you would probably cover that in your original agreement with them. So
Yeah.
you're saying in certain circumstances, we might have to pass information to a third party.
Yeah, I mean, it's on the kind of confidentiality. It's only
Yeah.
and then if it's a referral or whatever, you kind of tend to discuss that with the client. But your advice would be to have the consent in writing.
Yes, I think in that situation you really need it. So if you haven't got it in the original agreement, I would get them to give their consent in writing.
Yeah. There's also a suggestion, well, should I stop making notes altogether? Because that seems to make me vulnerable for having to kind of supply them to clients. And
I think this is a major concern for a lot of people, and unfortunately this is where there are certain decisions that increasingly seem to be GDPR related rather than related to actually what you're doing. So I have discussed this with the trustees of COSRT, and again there will be some guidance, but it is clear that their view is that you should not cease to make notes, because it's hard to see how you can effectively manage your clients and the advice that you're giving to them without having some form of practice notes.
No, I think
obviously
I'll remember everything if I don't write some things down. So
yes, you might want to be careful about exactly how you word some of the comments you might make, but I think you would do that anyway, probably. But increasingly bearing in mind that they could potentially have access to them. But the idea of ceasing to make notes just because of GDPR, I would say, is it's not a good idea. You've got to be able to provide the proper service, and again, defend yourself in the case of a negligence claim, for example. If you've got no notes of the meeting, how do you defend yourself?
Yeah, so it's not in the best practice to stop keeping them.
No.
And what kind of information do you have to give if you get the subject, what's it called, like access
request? Yeah. There is an existing on the ICO website. If you wanted to look at this, there is a code of practice to do with subject access requests. It specifically is the old regime and talks about the 1998 Act, but a lot of the same principles will apply. What it says under there is that in order to have a request, it must be in writing. So a verbal request is not sufficient. You have to be absolutely certain that the person making the request is the person that it should be, because you do often hear of third parties asking on behalf of someone else.
It's quite often, mother or a partner or somebody would like some information, and of course you can't give that.
Absolutely. Once you've received the request, you can't change any of the data. So you can't sort of doctor the database that you've got once you've received a request. And you do then have to comply with that request.
What do you have to give? Every
Okay.
information
You
you have
do,
on that client?
depending on how much information you're holding, I know that a lot of the schools, for example, who get these requests regularly, instead of copying all documents, because it would be a huge quantity, they just provide a summary of the information they're holding.
Okay.
But if it's a relatively small amount of information, you would be expected to copy it. You should ask the data subject if they want it in hard copy or electronically. Increasingly these days, people are quite happy with electronic. You should provide.
Have to make sure it's secure again.
Again, yes, absolutely, yes, quite right. So you've got to tell them what information you're holding, why it's being held, and if any third parties have access to that information. Now, there are some exemptions, so as to when you have to provide that information. If the information they're asking for contains reference to a third party, you either have to get that third party's consent, or you provide a redacted version of the document, so with bits blocked out that refer to that other person, or you can actually go back and say, we cannot provide this because a third party is involved and for reasons of confidentiality we can't. I mean, I would suggest in the circumstance where you're dealing with couples, this is going to arise regularly, that there's always going to be another party referred to in the documentation. So it's just care needs to be taken with that. You've got to comply with the request as far as possible, but equally you can't disclose details of the third party without their consent. There are certain other exemptions. So, for example, if you were in the middle of a negotiation with a client when they'd made a complaint, they couldn't then ask for the details of that negotiation. So, or if there was an ongoing piece of litigation, they can't have access to that or to legal advice. So there are certain restrictions. There's also an exemption for information provided by a health professional, which if you disclosed it would cause serious physical or mental harm. So there are some limited exemptions there, but you need to be careful about using those. You'd have to make sure you fell within those definitions. So in principle, you should provide access to what they are requesting, but subject to other overriding issues. If there was something to do with child protection, it may be that you would be justified in not providing that information. So,
for example,
I don't know exactly whether your clients are, members are dealing with clients and dealing with children, but it may be if there was a concern about a child protection issue in relation to parents, for example, or if there were notes from a parent about a child, you might not wish to disclose those notes to one or the other because of concerns about child protection implications. So the sort of safeguarding regime would trump GDPR for these purposes. But as I say, just take care on trying to rely on exemptions. The point is to be transparent as far as possible.
And these requests, if it's an ongoing client that I've seen for, 3 years, and they want all their data. In the new regime, it's very much saying it's got to be kind of legible. It's got to be something that can be looked at by somebody else. Most of my past notes are completely illegible. So
there's nothing that says that the notes you keep that are personal notes have got to be legible.
I'm sure there was something that said that they have to be in a form that can be given access to.
I suppose the issue is if they were completely illegible, then the question would be, why are you retaining them?
Well,
although you could argue that you can read your own notes, obviously.
yeah,
But I don't think there's any requirement. There's no additional requirement that says if you keep personal notes, they've got to be in a form that is easily understandable for the data subject. So basically producing notes, anticipating there might be a request for access. I don't think that's the requirement, no. But obviously if there are notes on the file, then theoretically they can have a copy of them.
yeah. Okay. That's a lot of things to think about.
It is,
Implement
yes.
in the next month.
Well, I think on that,
Days.
on the matter of the timetable, obviously it's only a month away. I know very few organisations who will be completely prepared.
Yeah.
So I think if your members feel that they're not yet prepared and won't be, the most important thing to have in place is a plan.
Yeah.
So if you can produce a plan that says, I've done this, I've updated my paperwork, I've changed my agreement, I've contacted my current and ongoing clients, I've changed my paperwork for new clients, but I won't actually be fully compliant until, let's say, January 2019. At least if you've got that plan in writing, if there were a question mark about how compliant you are, then you will be able to produce that as evidence that you've addressed the issue. And also any training, attending any training is also evidence that you're addressing the issue.
Yeah. And the kind of having a plan for the subject access request.
Yes.
What would you suggest that would look like?
I suppose the most important thing there is that you would know how to access it on ensuring that your database is held in such a way that you could access information quickly.
Yes.
So that may involve, for some people, if they've got historic archives that are paper form, but more recently everything's electronic, you might want to bring the paper documents into the electronic form so that it's a bit easier to retrieve. Or it may be that you look at changing your directories or your storage so that you can get everything to do with that particular individual almost instantly. Because the problem with the access requests, if you're dealing with one, that's fine. Taking a month to produce that information is not an issue. But let's say you've got 50 on the same day. How you deal with a highly unlikely, one would hope, but it's dealing with large quantities that might make it very, very difficult for a normal individual.
Keeping that in mind in any of the data processing, basically, that if you need to produce it, how to make that as simple as possible for yourself.
Absolutely, and working out what form is best for you to provide it in, you know, how you're going to deal with that request, you know, whether you need to get some additional help in to assist with that, or whether you can do it all yourself, whether your system is up to that. So it may involve a bit of a review of how you're holding your database of clients at the moment, and perhaps streamlining that a bit more. Yeah.
Okay, well, sounds like a busy month coming up.
The more that can be done in the next month, the better, to be honest.
I think it's just kind of getting your head around it and starting to think about it and starting to implement it and sort of. And I think not to be too anxious.
No, not at all, but just taking active steps.
A lot of these things have been there, but I think it's just people haven't necessarily known about them as much. I think now there's lots of emails and things about GDPR, so everybody's suddenly woken up to the fact that we are meant to be complying with these things already.
I think there will be a lot more general public knowledge about data subject rights, so people will know they can ask for information. So I imagine the requests will increase.
That's. Don't want to think about that.
No.
Anything else we should know?
I think that's covered most points I had in my notes. So, but obviously we can continue to deal with individual members' requests.
If anybody has any more questions, they're welcome to send them to me.
And presumably we can produce answers that we can circulate to all members.
Yeah. Okay, well, thank you very much, Helen.
You're very welcome.
Hope this has helped all the members, and if not, contact me at the ecm@cosrt.org.uk. Thank you very much.